Welcome to the Professional Edge. My name is Sean Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge for north of 5 years. What we talked about last session was wealth alignment. We went all around the horn on that one, from anywhere from investing to asset protection to aligning your taxes and your strategy. So let's take this opportunity to focus on wealth alignment and how your estate plan comes into play with that. So wealth alignment and your estate plan, that takes into account how are your assets titled? That's number one. Number two, are there things that supersede your estate planning documents? And therefore, you need to take a look at that, because it doesn't matter what your estate planning documents actually say, because the contract actually determines where those benefits will go when you pass away. So wealth alignment, EP, that is estate planning. That's what we're talking about now, how we align things. Being a tax attorney and having completed over 3,000 estate plans for our clients, I understand the nuances of those things and also how the financial instruments work and in alignment with your overall wealth plan. So the very first one is joint titling of an account. Let's say a bank account, husband and wife own it jointly. And the husband's document says, I leave everything to my surviving spouse. Not a problem. Well, does his last will and testament have anything to do with where that bank account is going to go? The answer is no. The account title actually controls. So if it's a joint account, then that joint account holder is actually going to hold that. Now, the reason why I say this on aligning your wealth and your wealth decisions with estate planning, we see a lot of clients that get older in age and they go ahead and add their son or daughter onto their bank account. So in case something happens, the daughter can gain access to those funds to help out mom. I see it all the time. Okay, so mom says we're going to split everything in my estate equally 50-50 between my son and my daughter. Well, mom passes and, the account at the bank has actually grown pretty substantial in size. It always happens. Let's say there's $100,000 in that account. Got to remember that mom added daughter to that account about a year ago, and daughter's never really needed to do anything for mom, but mom just added her on the account just in case, did some of that napkin estate planning. Well, that account is going to pass to daughter, all $100,000. That's daughter's. Now, it doesn't matter what the last will and testament of mom says. It says split this equally between daughter and son. What actually happens is the account title controls. So that's not any wealth alignment on the estate planning side. This is a complete faux pas. So daughter actually inherits an entire bank account, $100,000. By law, she does not have to share that with brother. And I will tell you, working with those 3,000 estates, money changes people, especially when mom or dad pass away, and now the kids are receiving their inheritance. Well, daughter may have a very pushy husband, and he says, you know what? Your mom put you on that account, and that's going to be our money. And then whatever is going to be controlled by the will, you'll split that equally with your brother. Well, the controversy ensues. So that's not wealth alignment. That is just dysfunction. So wealth alignment with estate planning, you got to understand what actually is controlling. So by simply adding the daughter to the account, mom estate plan was actually circumvented because the daughter's going to inherit that bank account free and clear. She gets all 100. And you say, well, she can give it to her brother. Well, she can give $19,000 to her brother, gift tax. And then she can give the brother's spouse 19 grand. That's 38. That's not all 50. So If you exceed that, we're going to have to file a gift tax return. There's ways around it, but it complicates things. Somebody wasn't paying attention who drafted that last will and testament and not checking on things to make sure things are aligned and say, okay, well, if daughter's on this account, you know that she's entitled to that. And therefore, we need to probably modify the estate planning document or the trust document to take that into account. The other thing on wealth alignment for the estate planning, here's the other factor. Well, as soon as mom added daughter to that account, she now exposed that account to the claims of the creditors of the daughter. So daughter gets in a divorce. Guess what? The divorce attorneys are going to say, show me every account that you're on title. Well, there it is. That account now gets into play in daughter's divorce. And as you divorce lawyers are hearing this, yes, you know I'm speaking the truth because your document dump says, give me every account where your name is on that title, whether they contributed or not. The court doesn't matter whether you contributed or not. They're going to say she's on that account and show me the account statement. It's $100,000. Now the daughter is fighting to keep mom's money away from her ex-husband. That's not alignment. That is dysfunction junction. So again, having the disciplines of a tax attorney, a CPA, and certified financial planner, putting these things in alignment, just as simple as adding a person to a bank account, you create all this confusion. That's not alignment. So if you, a listener here on the Professional Edge, have added a son or daughter to your bank account to give them access just in case, well, that right there should be the impetus to give our office a call at 404-250-9798. That number again, 404-250-9798, to get your planning, your wealth in alignment. So that's one very crystal clear, very simple example of estate planning alignment with the overall plan of the client. What's another one on wealth alignment regarding the estate planning arena? Well, it's on the beneficiary designation of a life insurance policy. So the life insurance policy, primary is normally the spouse, contingent beneficiary are the kids in equal shares, period. Done. 2 lines, simple as can be. Well, the insurance agent that did that policy, sold the policy, drafted the beneficiary designation. I'm sure that insurance agent is not a licensed attorney or understanding the difference between per stirpes or issue per stirpes or per capita. So what does that actually entail? Well, as an insurance agent, he says, well, we usually name the spouse as the primary beneficiary and kids as contingent beneficiary. Sign here. That's on the application. Have a nice day. Policy gets issued. Well, the attorney who drafted the last will and testament says, you got life insurance? Yep, got life insurance. Who's the primary beneficiary? Well, it says spouse. Who's the contingent beneficiary? The kids. Well, that matches what's in the estate planning document. We're good. Have a nice day. We don't need to do anything with the insurance contract itself. Well, let's step back. Who's doing what? Well, the insurance agent is not a licensed estate planning attorney, so he's not licensed to give estate planning advice. And the attorney is not a licensed insurance agent majority of the time. So therefore, he's not going to give information, but he, quote, did his job on verifying who the primary and contingent beneficiary is. But pump the brakes. Here's where the alignment is not in alignment, because that contingent beneficiary on the life insurance policy needed to include issue per stirpes. And what does that mean? Well, that means if that son or daughter was going to be the beneficiary, but unfortunately they were predeceased, dad never got around to updating the life insurance policy beneficiary designation. We know how that goes. So now mom's passed away. She was the primary. Contingent now drops down to daughter, and dad is thinking that, well, daughter is going to get half of this, and son's kids are going to get half of this. Well, all it says was the contingent beneficiary was son and daughter, period. Guess who's going to inherit that life insurance policy? It's going to be daughter. She is the only surviving beneficiary. What should have happened is son and daughter, issue per stirpes, which says if son's not available, his kids will receive his half share of that. So again, that's another alignment, the wealth alignment. These are nuances, but yes, they happen in real life. I've seen it in my 25 plus years of practice. So not having your wealth alignment with your estate planning, then that causes a lot of heartache. So you disinherited your grandchildren. Think about that for a second. Because I didn't have everything aligned, looked at from a different perspective of a tax attorney, CPA, certified financial planner, I disinherited my son's kids. My very own grandchildren got disinherited because things weren't in alignment. That's a pretty sad afternoon. Okay, you say, hey, I'm not going to realize whether this happened or not, but I would rather know that things are in alignment, that you're not going to have a chance of disinheriting that grandchild. So if that is an impetus for you to get your wealth aligned, especially your estate planning decisions and how your overall assets are going to be distributed, give our office a call at 404-250-9798. That number again, 404-250-9798. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on The Professional Edge. I appreciate your time listening.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA, for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.